Look, we're talking about parents providing financial assistance or advances to their kids. Just how that might be covered, I just sort of said, just advances, do we do it by gift or loan? Will they ever be challenged? Whether you're helping out with housing, making gifts, loans with the mortgage, grandchildren, they're helping with school fees. We want to make sure that the money goes to your child, that's your intention, rather than to your in-law who has now filed for some sort of divorce or separation. If we're going to leave a business, making sure it's in control of the right siblings, rather than having a sibling fight. Dividing control if we need to. Yeah, just thinking about what's going to be the best way. Should we have our children involved in the executives or trustees, or should we have someone else who will be independent and look after all their interests? If we get time, we'll try and cross some of the income tax consequences of making distributions from trust to kids. It's quite evident that parents always want to help their children out. If they've got enough or spare cash, don't have spare cash, often they're putting their kids ahead of themselves. One of the reasons why financial assistance is needed so much is because of that increased price of housing, as we're talking about on the news every day, has become more expensive, and the cost of living, cost of school fees, all those things have sort of significantly increased. As we're also living longer, states are passing to our children when they're 50 or 60 years of age, when really they probably need that money when they're earlier, probably in their 20s to 50s. That seems to be the biggest demand. The cash on people in terms of getting married. Kieran and Erin recently got married, not a cheap affair. Sending girl, obviously, anything between sort of $5,000 and $6,000 a year to $25,000 a year, and if you're got kids at boarding school, there's another $20,000 a year on top of that after tax. And if you've got a number of kids, you've got the multiplication effect there. Mortgages, people always have their biggest mortgages when they're starting off, and often parents want to help kids get into a business. National Senior Study 2012 said that parents are giving $22 billion a year to their adult children. So it's big industry, everybody does it, and it's across the board. And another statistic from one of those websites, finder.com, says that 86% of Australian parents are providing help. So it's big numbers in terms of overall dollars and also the percentage of parents that are providing it. If you gift the money, then it's gone. You have no control over it. It's not protected. But if you make a loan, we're going to work through how you can protect that and have the money repaid to you if there's a marriage breakdown. The problem with the gift is it sounds like a good idea. It's originally what we always think of in our head, but it doesn't sort of cater for that situation where if you need cash later on, you live, well into your hundreds and you need cash just to support your life. There's no way of getting that money back if you're simply giving it away. If your child goes through a divorce, that's the obvious one. It might be that your in-law is walking away with half of the gift, whereas you would have much preferred to see it go to your grandchildren rather than leaving the family. Children going bankrupt, we have about 7,000 bankruptcies a year. So we want to make sure that we don't pass away and leave an inheritance to our child while they're bankrupt. We'll just go straight to payment of their costs. And people must say that that wouldn't happen very often, but it does actually happen quite a bit. Also, if we've got a family dispute and you've assisted one of your kids, there's no chance of getting that money back if it's been gifted. So sometimes you might want to have that control by making it by way of loan. So this is sort of a classic example of where people got it wrong. Nice family, had 7 children, 2 boys, 5 girls. Mum and dad were in their 70s looking towards retirement. Their 2 oldest children, boys, and they and their families, the boys had wives and their own children. They all lived on the Stone Fruit farm and worked together. So the boys have been working on that farm for 35 years. Stone Fruit wasn't overly profitable, so that the kids were really working for a subsistence sort of living. There wasn't great dollars to pass around. But it was a good family. They all got together at Christmas time. And mum and dad sort of made it quite clear that the farm was going to be left to the two boys who'd been working on the farm for the last 35 years. Of course, the youngest daughter's a lawyer, and she joked that it doesn't matter, that the girls will be able to make a family provision claim. Now, it seemed like a joke at the time, but obviously mum and dad were concerned, and the police were very concerned that the farm may not be theirs after all these years of sort of that subsistence living. So mum and dad didn't really get any good advice. They decided to transfer the farm while they were alive. There were some stamp duty concessions which were available for doing that. So they were able to do it stamp duty free. There's no capital gains tax because they'd owned the farm for such a long time. Everything seems to be good, and mum and dad were going to stay living in the house that they had always been living in for the rest of their lives. And there was an agreement entered into between the boys and mum and dad about that. Anyway, no one could have forecast, but one of the spouses of the boys applied for a property settlement approximately 6 months after the farm had been transferred through. The farm had a total value of just over $10 and had existing debt on it of $500,000. So when they went to the bank to ask for a loan to pay out that spouse, the bank refused. So the only thing that could be done was to sell the farm to meet the family court orders. The farm was sold, but the most devastating thing, mum and dad lost their home, which was on the farm, and they were going to live out their lives just because they had the farm out of their names. They come in their names, and of course, any sort of property settlement between the son wouldn't have affected their lifestyle, and they would have been able to live on their farm for the rest of their life. So this all an outsider. If we're going to do a loan, it can be a really simple sort of a document. You just need the kids obviously to sign off on it. Typically, we're talking about loans without interest, and we need to just nail down a repayment date so that we've got some certainty about that. Now, if nothing happens untoward, then we're required to repay that loan. But if there is a problem, then of course we will be able to make demand to repay straight away. So typically we put, here's a loan, it's repayable on demand or by 20,050 or 60, so a long way down the track. I always say put them in a written agreement. Only has to be an acknowledgement. You know, I, son, acknowledge having received this loan from mum and dad. Just the amount and then the repayment date and a place for everyone to sign. In this particular case of Hayes, it was a bit unclear whether it was going to be a loan or a gift. But the deceased daughters purchased a block of land, and then her parents contributed a lot of money to the upfront building cost of the property and its ongoing maintenance. So essentially, on this property together, and the daughter looked after her parents from 1985, so quite a long period of time, all the way through to 2013. So my quick addition, I think that's 28 years. Now, in their will, it had a provision that said, I declare that all monies given to my daughter during my lifetime were gifts. If any monies were given as loans, then I forgive all loans. Now, most of mum and dad's money had gone into the property, and there wasn't much else at the time of their death. What the son argued, so the brother of the daughter had been looking after mum and dad, was that this was really a loan and that part of the property should have been in mum and dad's estate. It shouldn't just have been owned by the daughter. There were no deeds or anything to interpret this, so the court just had to work out themselves. And the court at the end of made a decision that the monies were advanced by way of gift. It was not to be a loan, and that the deceased estate did not have a beneficial interest in the property, and the son was unsuccessful. Now, a lot of the time it turns on facts, but they found him to be particularly unreliable. So that's why they found in favour of the daughter in that particular case. So there was nothing for the son to fight about because the bulk of the assets had already passed through to his sister. In another example, in terms of how you might record these loans, we had a set of parents who had 9 children, and they were position where they could help out their children, but the amounts that they helped out their children, there were some that never received any assistance during, and there are others that received up to $500,000 from mum and dad. But every child knew about mum and dad's black book, and in that black book was the details of the loan, how much you borrowed, how much you repaid, when you received that amount of money, and there was your signature. And unless you signed the book, you didn't get any money. So everyone had it. So at the time of their death, all we had to do was go to the book and work out what they were owed. And obviously that amount of money that was owed was part of their estate. And mum and dad divided the estate between all the children equally. And obviously you got, as part of your gift, your loan. Now, if someone had a $500,000 loan and they were going to receive $600,000 under the will, they'd get their loan back plus $100,000. If somebody hadn't received anything during their lifetime, then they'd obviously get that $600,000 in cash. So it's a very fair way of dealing with. People might have got lucky and had an advance during their lifetime, but those kids who had missed out were all treated equally upon death. It's important to make sure that there's a record and that it's beyond sort of challenge and people are aware of it. Fairness is sort of known for everyone. And then just in terms of making that knowledge widely available, this is sort of the transparency. I think there was always a period of time where people kept their wills secret. Today, because of superannuation, the value of houses and things, we've got many blended families. It's better to have wills and succession planning early so there's no surprises and any outstanding issues can be resolved during mum and dad's lifetime. That way, there's transparency from the start. If you have an issue, it can be hammered out before death rather than it resulting in a big surprise after death and costly litigation, which we're reading about in the paper every day. Be careful with loans that you do put a repayment dated date, then of course they might become statute barred. Now, one of the earlier decisions sort of said, look, until a demand's made for a loan that's repayable on demand, that is when the loan becomes repayable, and you've got 6 years from the time of that demand to commence proceedings to recover your debt. Now, that was held as sort of the correct law after an examination of our Queensland Limitation of Actions Act. However, there was an earlier decision, and the decision of the High Court of Australia goes back to the 50s, and what it said was they discovered that there had been some advances to a son during his lifetime, and the son sort of initially said, oh, those monies have been repaid, but the executors commenced proceedings against the son to recover that money. Again, his evidence was not all that satisfactory. His truthfulness was in issue, and he was required to repay those loans. But, and perhaps, it wasn't based on the original decision, but what the court said, and this is the High Court, a loan that is repayable on demand, then the right to call up for that loan starts. Therefore, 6 years after you make that loan, it's going to be repayable. And if you don't make that claim within the 6 year time period, then you're statute barred from commencing proceedings to recover that loan. So if you just have a loan repayable on demand and there's no 2050 repayment date or something of that type, then it won't go after 6 years. So it's really important that you do put a repayment date in there, because otherwise you're going to have that sort of problem of recovery. So I say the best practice is to have the earlier of demand or a fixed date. And I'm using that 2068 because if we have a good family, that money's not going to be made. Help with housing, just how you might do this. There's different ways of obviously doing it. Across the board, again, this is from finder.com, they said that 19% of the population relied upon their parents to provide them with housing, or they were receiving free or low rent. I think we all know that most kids don't see to pay board even though they're living at home until their 30s. So just consider this scenario. We've got two parents who have a son who they love very much. He's married to a drug-addicted actress. The parents want to help their son buy a house, but they're concerned there's going to be some sort of family law ramifications. So what they do is they actually buy a property and allow their son and his wife to live in that property rent-free. Now, the problems with this scenario is, how is there any incentive for their son or their daughter-in-law to keep the place in good condition, to make renovations to it, keep it in good repair, or any sort of changes? And even clean. We've had the situation, and in that particular case, the in-law simply said, call your father to get him to fix it because they own it. There was no incentive for them to fix it themselves, even though they were providing it rent-free and they were obviously getting a great benefit. It's often not seen like that. So you need to give those children the incentive. But we're still worried about, that divorce. If we give away $500,000 to our son to buy a home, the son and wife purchase that home together. In the event of a divorce, if they've had sort of one of those medium or long-term relationships, and that can be, with family court regard, a relationship of more than 14 years as a long-term relationship. So 0 to 7 years is short-term, medium, and 14 plus is seen as long-term. And that's where those sort of medium to long-term relationships, where typically the contribution of the parties is regarded as being equal and the assets might be split. That's avoiding the generalisation. But in that type of scenario, mum and dad gave $500,000, $250,000 is likely to be leaving the family and going with their ex-in-law. So buying a house for the kids to live in rent-free, that's not a solution. Giving the money away to a child to purchase with their spouse, again, can see loss of half that gift to the in-law. So what we're suggesting is that there be some sort of a loan agreement. Again, the money's lent to both of them. Record the loan agreement, so it can't be argued that it was a gift of money. Get both parties to sign. Get them to sign before you give them the cheque, because people just about sign anything when they see that money, but once they've got the money, they're very reluctant to sign. And in the event that there is a divorce or something of that type, then you're going to be entitled, the children will be entitled to the growth. So your son-in-law and your daughter, they'll be able to share in the growth in the property. So if it's purchased for $500,000 initially with a loan from mum and dad, if it grows to $1 million in value, then your daughter and son-in-law, they can share in that increase in growth. Family court will make orders about that, but the original $500,000, that'll be repaid to mum and dad. And then, of course, once the divorce is finalised, they can advance that back, keep that in the family. In terms of whether loans are a sham, sometimes people say, hey, look, it's recorded as a loan, but it was never intended to be repaid. Obviously, the courts just look and see what the intention was. And I think the intention should always be that the loan will be repayable. And you can even mention in the divorce scenario that it was to be repayable. You don't want to say that if you don't get divorced, it won't be repaid. It's just something that remains repayable. And if something's a sham, if you do a loan document but you never intended it to be repaid, then sham transactions are always disregarded. And this is just a quote from Gibbs, who went on to be the Chief Justice of Australia, saying, where powers or privileges have been brought into being in appearance rather than in reality as a device to assist one party to evade his or her obligations, sham transactions may always be disregarded. So that's sort of common sense, I think. But look, properly executed loan document is always going to be found to be enforceable and not a sham, if that's what you intend it to be. What helps you with a loan, obviously, is having a document in place. If it's a loan from the family balance sheet, it's an asset of the family trust. If a loan is referred to in the will, that's obviously going to be evidence that it was a loan. If there's been any interest payments, details of those, but typically there's not interest payments in a family arrangement. And obviously the main one is to have a loan agreement signed by both parties, so there's a written record of it. We're not disputing about the terms of that agreement. Just sort of some of these that have gone through. There were several payments made by the testatrix to one of her sons during her lifetime. Notwithstanding that there was no documentation, the court considered it to be an undocumented loan between the parent and child, because there was always an obligation to repay it. In this decision of Gray and Guardian, in the absence of any agreement or express mention of a gift, the court held that the son revealed that he understood there was some obligation to repay, although only if requested. And this was because the court found that where amounts were part of a loan payable to the estate plus interest from the date of the testatrix's death, that it was a loan and it was going to benefit the estate rather than the in-law. Pelly and Nolan is a decision the other way. The father loaned $250,000 to help him buy a property. Oh, sorry, no, this is one where it was found to be a loan. Father loaned $250,000. After that property was sold, the father loaned another $70,000, which was used to purchase a new property. The son did not pay back any of the money, didn't pay any interest, but the court found that on balance of probabilities, it was likely that the son would have repaid the loan. So the sum of $320,000 was considered a liability and taken out of the matrimonial pool of assets. Really just touching here, both parties should sign it. There are no tax or duty implications on the loan agreement. In New South Wales, if it's seen as being a refinance rather than an initial advance to purchase a home, there might be duty of 0.4%, but it's only a nominal amount. Title office fees in registering these loan or mortgages over the properties, a couple $100. Legal fees for drawing up a mortgage or even a loan document are normally pretty nominal and normally sort of trivial compared to the amount of money. No income tax consequences if you're not charging interest, so it can be quite handy. Help with grandchildren and school fees, that's something we see a fair bit of. Again, those private schools, we're talking about after-tax money. We've got 3 children. Real question about how can you afford that $60,000 a year to send them off to a private school. Just one of the percentages, 30% of working Australians aged over 50 said they want to help pay for their grandchildren's school fees. We can't have grandparents' income being diverted to children who are minors because it's taxed at the highest rate, so that's higher than the marginal rate of tax. It's taxed at 49%. So what can we do? Money can be advanced by way of gift to the parents or can be paid directly to the school. It's not going to be any tax advantage for that. Obviously, if one of the grandparents passes away and establish a trust under the will, then that trust can make distributions to the school for that child, and that won't be taxed because it's a trust under a will. So up to $18,000 a year, minor children can receive from testamentary trust, but if it's a new trust, then we'll have to look at post-taxation consequences. It'll be post-tax. A lot of grandparents pay the school direct. I don't know, don't they trust their children? But it seems to be a good way of making sure that the fees are paid and there's no dispute about that. Ensuring money goes to the correct person. Again, we're wanting to help out, and it's really just making sure that up front we've got that document showing that it's not been a gift of money, that it's been a loan, and it's always been intended to repay, so both parties are quite clear. What the family court can do is obviously when they're dividing assets between the parties, they're looking at all the assets, so all the property of the party, so that's both the husband and wife. It doesn't include any of the grandparents' money unless that grandparent is very, very ill and likely to pass away, and there's likely to be a distribution to one of the parties to the marriage. Alter egos are obviously included under Section 79 and they're dividing up that property, but otherwise when you're looking at that asset pool of assets, if you're talking about a bank debt, that's taken out of the asset pool before there's division of the asset pool. And of course, if it's or cousins or uncles or brothers, that's taken out of the asset pool because it's your loan first. Here is an example where it went the other way. The father gave his son and his son's wife $240,000 towards the cost of buying and building a house, and again in 2005. The evidence as at the time when the advances of neighbours disputed, the couple and the father sought to recover the money. There was no formal demand for the repayment of the money, but the court found that if the money had been described as a loan repayable in a month, the wife would not have accepted it. So her evidence was this was clear gift of money, and if it had been a loan document, she would have refused to sign it before she got the money, and the court believed her on that aspect, and therefore that total money came out of the that money was regarded as a gift, and the amount was in the asset pool that could be divided between her. The not having a repayment date is obviously evidence more that it's going to be a gift rather than a loan. So in that particular case, the wife received $240,000 out of that asset pool. So out of that $353,000 that he probably intended to be for his son, he only recovered, or the son only received $113,000 and $240,000 to his wife. Yes, again, this is just sort of details. I'm sort of going a bit over time here. Recording the loan is the sensible thing to do. In terms of passing businesses down to siblings, again, it's just getting together and having a plan in place. Typically, we have them called them governance agreements. In Germany, they call them Berats, where sort of 90% of small to medium enterprises have these documents in place. But really, it's just a document to say if the maternal leader of the family passes away, how the business is to be controlled after death, which all of the children, just one, what management's going to stay on. And if we've got a situation where we've got kids who are just not up to taking on the job, then we might have an advisory board, account lawyers, bankers, industry experts, good friends, who have a deep knowledge of business. They can run the period of the business after the person's died. They can work out the kids are not capable of running the business. They can organise it to be sold. And then that way the sale proceeds can be passed on or put into passive assets, which are going to provide an income stream for any spouse or children who are left behind. So yeah, look, this is my example of the naive children. Their father passed away. There was litigation going on, which they're unaware of. No one else was aware of the litigation apart from the lawyers, obviously. And they just weren't up to the task, and the size of the estate was reduced considerably. Personally, if they'd had an advisory board, some sort of governance agreement in place where they could have been helped, someone that had a deep knowledge of the situation, then we're talking about $10–15 million could have been saved. The advisory board are just an advisory board. They don't actually have a real role or a litigation role where they might be sued until the death. So you can get the best sort of talent onto those things, and they don't have any liability until that death role. Divide and control. Ensure there's no fights between siblings. Again, just being careful, you know your kids best. Picking a trustee that's going to be most suitable so there won't be any disputes. Someone who's going to be able to mentor them, just train them simply to take on the responsibility of the assets they're receiving and to minimise the likelihood of contest between the kids. Again, if we considered our Stanthorpe family farm scenario, we could have easily had a situation where the property remained for the benefit of the boys and it wouldn't have been lost in a divorce. We just need to pick a trustee who's obviously going to be the sort of perfect person who's going to keep the money in trust for them and act in their best interests. And more importantly, mum and dad would have had somewhere to live and have seen their farm being sold out during their lifetime. All right. Has anyone got any questions? There's nothing in the little chat box here. No worries, Bruce. Thank you. Has anyone got a query? As I say, these will be available. If you've got someone who might want to watch it, we can email the link through to you and they can watch it after today. Thanks for listening. Oh, hang on, Richard Fitton's typing a question. Come on, Richard, I hope you're speed typing. Oh, no. Okay. Thanks, guys. Look, we'll end it there. Any queries, just give me an email. Thanks for listening. And if you've got a topic that you'd like us to talk about, let us know, and we will address that soon.